Hello everyone, my name is Minnie Sethi. I hope you all are staying healthy. Today we are going to talk about Employment Standing Order Act 1946. What is main purpose of this act? Before this act, so many workers didn't know about terms of employment. For example, they didn't know about rules of leaves, shifting time. Even so many didn't know about grounding for firing. That's why main goal of this act to force employer so that he can formally define and publish condition for employment. Result of this act, both boss and workers know about rules and regulation. Obviously, this act will prevent confusion and unfair treatment. Where does this act apply? This act applies to whole India. Size of a business. This act applies to industrial establishment where 100 or more workers are working. But government can reduce this number by giving 2 month notice. Who is not covered? This act doesn't apply to state like Maharashtra or Madhya Pradesh, or this act doesn't apply to workers who governed by special government rules like railway or civil service code. Process. How standing orders are made. Standing orders are official rule book of company because in this book consists everything that workers must know from the day they join this organization until they leave this organization. First step, drafting. Employer must submit 5 copies of draft standing order to certifying officer within 6 months of that act applying to them. Consultation. The certifying officer send this copy to trade union or workman. They have 15 days to raise any objection. Hearing. Officer will listen both workers and employer. Certification. If rules are fair and according to laws, then officer is certifying them. Coming into force. Rules become active in 30 days after they are sent out unless there is any special appeal. Key features and rules of this act. Standing order must cover specific topics which are listed in this act like shifting time and attendance, condition for leave and holiday, how to terminate and suspend any employees, misconduct or disciplinary actions, subsistence allowance. If a company suspend employees for any misconduct during this time period, workers will not come for work, but he need money for survival. That's why section 10A of this act describes subsistence allowance. First 90 days, company should be pay 50% of their wages. After 90 days, company should pay 75% of their wages if delay is not due to fault of a worker. Section 9 of this act shows final certified rules must be posted on entrance and in all departments. They must be written in English and any language which is understood by most of workers. Section 10 shows once rules are set, they usually cannot change for 6 months unless both employees and employer are agree to change earlier. In order to change this rule, you have to send a new application to certifying officer. Penalties. If employer fail to submit drafts, then he has to give 5,000 rupees plus 200 per day if they continue do this offense. Acting against certified order. If any employer act against certified order, then he has to give 100 rupees plus 25 per day continue do this offense. Important authorities. Certifying officer. Certifying officer usually is labor commissioner who approve their rules. Appellate authority. If someone is unhappy with the certifying officer, then they can go here and they have to appeal here within 30 days. Labor court. If there is any dispute about interpreting a specific rule, then they can go in labor court. One most important thing, Employment Standing Order Act 1946 has officially repealed and replaced by Industrial Relation Code 2020. Difference between Employment Standing Order Act 1946 and Industrial Relation Code 2020. Here any business with 100 or more employees need to have standing order, but Only businesses with 300 or more workers need to have standing order. Bit narrow, but this is wider because here include supervisor who earn up to 18,000 per month, and journalists and sales people also include. Hiring someone for short time period was legally messy in this case, but here employer can hire workers directly for fixed time period. For example, they can hire like 1 year contract, and they have to treat the same way as they treat their permanent employees. So this is all about today's video. I think you got it, and thank you so much for watching this video. Bye, take care.